Almost from Lincoln's very election, certainly with the crisis of Sumter, issues about the Constitution and how Lincoln would conduct governing the nation and prosecuting a war became matters of not only interest to his contemporaries and concern to his contemporaries, but they have remained for years and years the subject of interest both for jurists, historians, and scholars interested in Lincoln. Today's speaker, Daniel Farber, is a graduate of the Illinois School of Law. After his graduation from there, he clerked for Justice John Paul Stevens of the U.S. Supreme Court. And after a brief practice of law, he became professor of law at the University of California at Berkeley, where he is the Sato Professor of Law. Today he will be addressing issues regarding the federal state, the state of federalism during the Civil War and the Lincoln administration, the presidential power exercised by the president, and other constitutional issues. So it is with great pleasure that I bring to you Daniel Farber.
Thank you for that introduction. It's a great honor to be here today, but I've just received a stern warning about timeliness, so I'm not going to expand upon that point, but I'll get directly into my remarks. In my book, I try to work through the major constitutional issues that confronted Lincoln just before and then during his presidency. What I'd like to do today is a little bit different, although it derives from that, which is that I'd like to situate Lincoln in American constitutional history between the framers of the Constitution in 1789 and our generation today. When we think of the architects of the Constitution, those of us who think about these things anyway, think of the Founding Fathers, and in particular of James Madison, who is often known as the father of the Constitution. In contrast, Lincoln is known as a defender of the Constitution rather than one of the creative forces. However, what we fail to realize today is that Lincoln was involved in reshaping the constitutional order at the same time that he was defending it. We have a tendency today to think of the Constitution as having emerged in perfect form from the Philadelphia Convention and then become enshrined in American history. But in fact, the Constitution that Madison drafted, or primarily drafted, was incomplete in important respects and ambiguous in other very important respects. The Civil War and Reconstruction were a transformative period in constitutional law. I think almost all constitutional scholars would agree with that. And it was really during that period that some of the major ambiguities and gaps were really addressed. So it was kind of a constitutional turning point. Lincoln played a role in that, although not the only role. So what I'd like to do is talk about how Lincoln filled three gaps in the Constitution that I think all remain relevant today. One is the most fundamental, the nature of the Constitution itself. Lincoln thought that our forefathers brought forth a new nation, not merely a confederation, but others thought the Union was merely an association of independent sovereign governments like NATO or maybe even the United Nations today. And that was a question that could be legitimately debated. I think there was a right answer, but there was grounds for dispute until Lincoln. The second constitutional gap related to the nature of the presidency. Today, the president is at the heart of our national government, the most powerful single individual in the world. But Madison's Constitution, the Constitution of 1789, is I guess I won't quote the line about the enigma wrapped in the mystery, et cetera, but if you look at what the Constitution says about the president and presidential power, there's a mystery about how broad or how narrow that power was intended to be. And Lincoln helped resolve some of those questions by setting historical precedents for presidential action. The third failure of the original Constitution was that it protected individuals against the national government. The Bill of Rights in particular, which Madison drafted and introduced into the House of Representatives, limits the ability of the federal government to invade individual rights. But it did almost nothing to protect individuals against their own state governments. There are a few small exceptions, but basically, under the original Constitution, states were free, almost without restriction, to violate the rights of their own citizens. And the existence of slavery is the most dramatic example of that. In the post-Civil War period, starting with the 13th Amendment, the Constitution was amended in a way that now provides protection for citizens against their own states, so that basic human rights and equality are protected throughout the country, not just from one kind of attack from Washington. I don't think that Lincoln envisioned all of the later amendments, but if you look at his thinking and what the amendments accomplished, the themes can be found in Lincoln, even if the legal details didn't come into existence until later. So let me start with the unsettled nature of the Union. One of the things that surprised me a little while I was working on the book was the difficulty of the issue of secession. There really is no smoking gun anywhere that says that secession is unconstitutional. There are some very good arguments, I think, and in the end, compelling arguments for why secession violated the Constitution. But it's not as simple and straightforward an argument as you might think. And for that reason, someone like Jefferson Davis could make the argument in favor of secession with a straight face. Jefferson Davis had his own version of American history that was different than Lincoln's. According to him, the British threat to the Americans led to an alliance between states, under which each state retained its sovereignty. I suppose you could analogize to the four allies in Europe during World War II, combining their forces but remaining independent. The states then appointed delegates to a constitutional convention. The constitutional convention wrote a constitution. The states themselves signed on to the Constitution, but they retained their sovereignty and their equal dignity until the Northerners violated the spirit of the bargain by trying to undermine the most basic institution of the Southern states. He wasn't being original when he presented this theory. John Calhoun had written several decades earlier defining this theory in great detail. and explaining the Constitution as a compact between independent states. A federal in contradistinction to a national government, a government formed by the states, established and ordained by the states and for the states. Therefore, Calhoun said, no such community as the people of the United States exists regarding in the light of and as constituting one people or nation. So I think there's just this great contrast between by the states and for the states versus of the people and by the people, and that's really the basic divide in constitutional thinking between Lincoln and the Southern constitutionalists. Lincoln, in fact, believed that the United States came into existence as a nation before the state governments themselves came into existence, and that the Union was older than any of the states and created them as states. He then viewed the Constitution as carrying forward the Articles of Confederation, which were perpetual. The Constitution calls for a more perfect union. If the older agreement was perpetual, then a more perfect one has to also be perpetual, and therefore secession is impossible. I think that's a pretty good argument, but it's putting a lot of weight on just a couple of words in the Constitution. I think there are some other supporting arguments, however, that are convincing. Now the question is, how is it possible for people to disagree about something this fundamental as to whether they lived in a nation or whether they lived in an alliance of multiple sovereigns? Part of the reason was that the framers of the Constitution themselves were never very clear about this, by which I mean that collectively they weren't very clear. A number of them had very clear ideas, but they didn't always agree with each other. Even during the Constitutional Convention, the framers debated whether separation from England had created separate sovereignties, which had then confederated, or whether independence was a collective action taken by the American people as a whole. After the Constitution went into effect, these very theoretical disputes about sovereignty were played out in very practical disputes about federal supremacy. In particular, there was great controversy about whether the Supreme Court or state officials had the last word about constitutional issues. I think everyone in this room is probably familiar with the issues of Lincoln's day about whether the president or the Supreme Court or somebody else at the national level had the final word on constitutional issues, a debate that began with Dred Scott at least and then was really brought to a high pitch with the Merriman case. But in the previous period, it hadn't really been that argument. Instead, the argument was that the states had the final word on constitutional issues. And so, therefore, for example, a number of important state judges claimed that their decisions were not subject to review by the U.S. Supreme Court because they were the Supreme Court of a separate sovereign and an independent sovereign. On balance, I think that the constitutional arguments against secession clearly outweigh the contrary ones. I think that the best reading of the historical record is that the Constitution did create a nation, not just an alliance. But until Lincoln, I think you had to concede that the Constitution did not provide an explicit, definitive answer to this question. In retrospect, how many lives might have been saved if they had just thought to include a phrase about irrevocably ratify, for example, when they talked about ratification. If we regard the point as settled beyond argument today, if we take it for granted that the United States is one nation, indivisible, we have to credit Lincoln rather than the Founding Fathers for making this clear. A colleague of mine, when I taught at the University of Minnesota, used to say that the issue of federal supremacy was decided by the great case of Grant versus Lee. and the ruling of Appomattox courthouse. So I think there's a good deal of truth to that assertion. We continue to argue about states' rights today, and you can even find signs of the old Southern constitutional theory peeking their heads up now and then in some of the modern advocates of states' rights. But we're obviously fighting on a far different battleground. We're not fighting about the fundamental nature of the Union and whether states are equal to or above the federal government. We're fighting at the margins about just how far the federal government can go in exercising its power, and that's a huge difference from the debates that existed before Lincoln. Now, the second point that I wanted to talk about was presidential power. One thing that I think that I found so striking when I was reading about this period was the difference between the scale of the federal government and of the presidency in the pre-Civil War period and what we see today. So let's see, in the entire country there were only 70 federal judges, 81 federal attorneys, marshals, and other court officials. So that was the law enforcement branch. No FBI, no tobacco and firearms service, none of those things existed. The Attorney General, when Lincoln came into office, had only recently become a full-time job. So we basically had a Justice Department that consisted of a part-time Attorney General. Lincoln's staff itself was minimal compared to today. I mean, compare Nicolay and Hay to the modern executive office of the presidency. In fact, the Congress did not appropriate any funds for White House staff until 1857. And it was well after Lincoln's death when the size of the White House staff reached 6. I mean, it's almost beyond belief now that, in those days the executive branch was very small and not particularly powerful. Lincoln, of course, as I probably don't need to remind people here, took extraordinary actions in the early days of the Civil War, in particular, calling out the militia, asking for 75,000 troops, proclaiming a blockade of southern ports, which was clearly an act of war under the existing international law, expanding the Army, authorizing the Treasury to give money to private individuals to use in recruiting in the North, which I think is probably the action that is most clearly unconstitutional of any of them, because the Constitution is quite clear that funds can only be spent on the basis of congressional appropriations. And then, of course, finally, the most important single act of executive power in our history probably was the issuance of the Emancipation Proclamation, in which unilaterally, without the benefit of a statute, the president essentially abolished slavery in the South. Essentially, so there are some qualifications and some question marks there, but probably, as I say, the single biggest presidential action in history. Now, today, I suppose these things would be controversial, but they wouldn't be shocking, because in the sense that we expect our presidents to take the lead in responding to national crises, and at some level, we expect them to do what needs to be done. We may disagree about what that is, and we may think that sometimes presidents go too far, but we do look to the president as more or less the leader of last resort in these situations. The presidency in Lincoln's era was a more modern venture. And if you look at the Constitution itself, it's not surprising. One of the surprises about the Constitution, though, if you look at it, is that it has relatively little to say about the president compared to what it says about Congress. The Article 2 of the Constitution, which discusses the president, is pretty short. A lot of it is given over to the mechanics of how to elect a president, and those mechanics didn't work and had to be revised almost immediately after the election of 1800. At the Constitutional Convention itself, they spent most of the time trying to figure out how many presidents to have. There was discussion of having 3, triumvirate. They decided against that in favor of a single president. Then they couldn't decide on the term of office. Then they couldn't decide if the president was reelectable. Then they couldn't figure out how the so they went round and around and around on these very basic issues and did not devote nearly as much attention to the question of what the president's powers would be in the end. The section on presidential powers is pretty short. It has some really important powers, like being commander-in-chief of the armed services and taking care that the laws be faithfully executed. It has other powers that are a good deal less impressive. There is, for example, they felt it necessary to explicitly give the power to the president to give a State of the Union address, and also to demand opinions in writing from cabinet members. The fact that they felt that those powers wouldn't exist unless they were specified makes you suspect that maybe they weren't thinking of the office in such grand terms, but you can't really tell. There's been a debate that started very shortly after Washington took office about the constitutional powers of the president. Robert Jackson, one of the great Supreme Court justices of the 20th century, once summarized the debate as follows: just what our forefathers did envision, or would have envisioned had they foreseen modern conditions, must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. And he added that a century and a half, now over 2 centuries, of debate and speculation yields no net result, but merely supplies more or less apt quotations on each side of any question. The framers, in fact, knew that they had not resolved these issues. In Federalist Papers, Madison himself said, "Experience has instructed us that no skill in the science of government has yet been able to discriminate and define with sufficient certainty its 3 great provinces, the legislative, executive, and judiciary." As an aside, I would say that it's obvious that Madison was no match for Lincoln as a writer. Now, I don't mean to say that the modern presidency was an invention of Lincoln's, but as defined in the Constitution itself, the office of the presidency was an ambiguous potential rather than a defined instrumentality. Lincoln was far from being the only president who helped shape the modern presidency, but he was among the earliest to do so and the greatest. He was the one who first made the full potential of the office clear, and for better or worse, he bears much of the responsibility for what the president has become over the years. So let me turn to my third subject, which is Madison's missing rights guarantee. The third gap in Madison's Constitution was one that I referred to earlier, the absence of constitutional protection for citizens against their own state governments. The Bill of Rights, which we all know about and celebrate, applied only to the federal government. So, and this is something I have learned from generations of law students, is not common knowledge. We think, for example, that the First Amendment keeps the states from engaging in censorship or establishing a religion. But the First Amendment doesn't do that. The First Amendment says Congress shall make no law. It's only the federal government that's affected. That wasn't what Madison wanted. He wanted to have those protections extend against state governments, but he didn't have the votes to do that. It's really only the Reconstruction era amendments, and especially the 14th Amendment, that apply the Bill of Rights to the state governments, and that's an outgrowth of the Civil War and of Lincoln's era. It's understandable that the Constitution didn't provide protection against state human rights abuses. How could it, when it sanctioned slavery, the greatest human rights abuse of them all? It might have been true in some hopeful sense that the nation was conceived in liberty and dedicated to the proposition that all men were created equal, but neither liberty nor equality were truly guaranteed by the Constitution. Freedom was going to reign in some parts of the country, but not in others. This was a situation that Lincoln acknowledged but believed to be unsustainable in the long run. The process of changing this constitutionally began under Lincoln, but was not completed until the years after his death, through the decade of the 1860s. He was deeply involved in passing the 13th Amendment, which was the cornerstone by abolishing slavery permanently. He lobbied hard for the amendment with gentle hints like the following to one member of Congress: "Your brother died to save the Republic from death by the slaveholders' rebellion. I wish you could see it to be your duty to vote the constitutional amendment ending slavery." Nudge, nudge. Now, the civil rights, the 13th Amendment was followed after Lincoln's death by the Civil Rights Act of 1866, by the 14th Amendment, and then finally by the 15th Amendment, giving blacks the right to vote. As I say, in concrete terms, Lincoln helped begin that process, but it went on well after he was dead. We can speculate about what his views would have been about the later stages of the process and what kind of role he might have played had he lived, but it's only speculation. What I think is more clear is the significance of the themes that Lincoln promoted as a kind of constitutional vision for the country. I think it's really instructive to line up some of what he said at Gettysburg with some of the later constitutional amendments, because they really strike a lot of the same notes, only in clumsy legalistic language rather than in Lincoln's great rhetoric. So Lincoln emphasized American nationhood, a new nation, this nation, any nation so conceived. And the first sentence of the 14th Amendment, for the first time, conveyed national citizenship on anyone born in the country. Until then, it wasn't clear whether you became a citizen of the United States first and then, by implication, a citizen of whatever state you were in, or whether you were primarily a citizen of the state and only secondarily a citizen of the nation. That first sentence of the 14th Amendment settles that. Lincoln spoke of the nation as conceived in liberty. The Due Process Clause of the 14th Amendment forbids the deprivation of life, property, or liberty without due process of law. He spoke of all men being created equal, not only, of course, at Gettysburg, but throughout his career. The 14th Amendment guarantees all citizens equally the privileges or immunities of the citizens of the United States and the equal protection of the laws. He spoke of a new birth of freedom, and the 13th Amendment abolishes slavery. He spoke of government by the people, and the 15th Amendment guarantees the right to vote. So although his language was not the legalistic terms that were ultimately part of the Constitution, the themes that he was developing, his vision of America and what America should be, what the Constitution should be, I think really finds concrete form in these later amendments. Of course, all of this was not completely accomplished within Lincoln's life or even in the decades after his death. To a large extent, it was only in the 1960s that some of these promises, for example, about black suffrage, were finally began to be kept. But we see the beginning of at least the aspiration beginning in Lincoln's lifetime and continuing forward. What is striking to me is the extent to which Lincoln's accomplishment was more than just defending something that already existed in the constitutional order. Instead, he took the lead in helping to fill crucial gaps, ambiguities in the Constitution. Our Pledge of Allegiance today speaks of one nation, indivisible, with liberty and justice for all. But neither the true nationhood of the United States, nor its indivisibility, nor its commitment to liberty and justice for all were obvious when Lincoln took office. That we take such things for granted today is in no small degree a legacy of Lincoln's. We may continue to call James Madison the father of the Constitution, but Madison's Constitution was flawed and incomplete. We would not have the constitutional laws that we have today had it not been for Lincoln. They say that every problem began life as a solution, And some of our problems today have their roots in some of the solutions of Lincoln's day to the constitutional issues facing them. But thankfully, our problems, difficult as they may be, can be solved without a repetition of Antietam and Gettysburg today. Something was accomplished through Lincoln and the accomplishment of his vision, and we live in a constitutional order that bears his imprint today. Thank you.
Thanks. Okay, we have a question right on the aisle first, then, and we'll take you next. So,
I thought that you would address the issue of executive power with Lincoln's suspension of habeas corpus, which has become an issue today of whether the executive can suspend conditions of the Constitution in time of war or hostility. You seem to have avoided it. Was that by...
Well, of course, I want to be focusing on Lincoln here rather than present issues. But in terms of the habeas corpus issue, although it's a complicated question, I do think there's some argument for a presidential power to suspend habeas corpus on an emergency basis until Congress has the time to act. Because of the possibility, which was even greater in Lincoln's day, that there would be no time for formal congressional action during a crisis. My general view is that probably supports Lincoln's initial suspension of habeas, but that it doesn't support all of the later suspensions, which I think have to rely on congressional ratification to support them. The larger question that you're raising, I think, is about whether the president is in some sense able to suspend not just habeas corpus as one specific judicial remedy, but in some sense the Constitution in order to defend the nation. And I think that's an interesting question in terms of what Lincoln thought and believed. He certainly talked at times as if his war powers and national needs were above the Constitution, or at least that he had a higher duty to save the country than he did to obey every individual clause of the Constitution. I think to the extent he believed that, we have to take that with quite a bit of a grain of salt today. But I think it's one of the deepest questions raised by Lincoln's presidency and one of the most interesting.
Thanks for addressing the question about habeas corpus. If the southern states could not succeed, or if they could succeed, what's your opinion on West Virginia, in effect, succeeding from Virginia? Could you just give us a thumbnail sketch? That's kind of an interesting what if. Thank you.
Yeah, that's a really interesting question, which I didn't talk about in the book because I was trying to stick to some of the really central issues. It really comes back, I think, to an old dispute that lawyers have about form versus substance. The creation of West Virginia followed the forms required by the Constitution. That is, the Union recognized a legislature of Virginia, which actually had jurisdiction over only a very few counties in West Virginia. That legislature gave its consent to the creation of West Virginia as the Constitution requires. Congress then gave its consent. A new government was formed in West Virginia. If you just look at sort of the sequence of legal actions, everything looks kosher. The real problem with it is that everyone knew that the legislature of Virginia that was purporting to give the consent wasn't the real legislature of Virginia, that the real legislature of Virginia, which was still in Richmond, was not about to give its consent. So the real question is, do you go with the fact that basically all the paperwork was in order. All the terms of the Constitution had been formally complied with? Or do you go through that and say, this whole thing was like a dodge, getting around the real intention of the Constitution in order to, accomplish something that was thought to be necessary? People tend to differ about how they approach things. Is it the letter of the law or the spirit of the law? I think there's some argument that even if the spirit of the constitutional provision on the creation of new states, I guess I should back up just to explain this. The Constitution says that new states can be created only with the consent of the existing state that they're carved, or states that they're carved out of. And so the question is whether that was really complied with in this case. And it was, in a formal sense, because something that the U.S. government claimed was the legislature of Virginia did give consent. But it was, it was a little bit like one of these tax shelters, where they move all the paper around and everything looks fine. But then when you go past that, it's sort of a house of cards. A colleague of mine from Minnesota wrote about a 100-page article in a law review on the question of whether West Virginia is constitutional, and concluded that on balance he thought it probably was.
I hope I'm not going off on a useless tangent here, but I'm wondering whether there's anything to be gained from comparing Lincoln's theory of the Constitution and his predecessors. I mean, I'm not trying to rehabilitate Mr. Buchanan, but I imagine that he thought seriously about the Constitution and what its prescriptions were, the point beyond which he could not go. And since this is a tipping point in American history, I was just wondering if that might be useful. If your answer is that no, there is nothing to be gained by comparing this exalted figure in world history to a hapless mediocrity, I'll accept that. But I'm just wondering.
Well, first I want to say more generally, not just limited to Buchanan, the answer is yes. And if you look back at, say, Jefferson and the Louisiana Purchase, you have one of the most striking earlier exercises. There's also a question whether Louisiana is constitutional in some sense because of the way the Louisiana Purchase was done. And Washington, of course, set a lot of important constitutional precedents. I think it's interesting to compare Lincoln's views with Buchanan's, which I haven't tried to do in a systematic way except on the question of secession. Buchanan's view on secession seems to me to be the most clearly wrong of any possible view. That is, his view was that secession was unconstitutional, but that he couldn't do anything about it, and that the federal government couldn't do anything about it because that would mean coercing a state. And I, for a variety of reasons, I just think that's completely untenable. I just think if you think about that for about 3 minutes, you'll realize that a situation in which there are a bunch of states that are behaving entirely independently, that the federal government has no authority over, but that they're still theoretically part of the Union, would just create all kinds of paradoxes and inconsistencies. So I think Buchanan was clearly wrong on that issue. In general, I think he took an overly restrained view of presidential power. Although I should say one of the interesting things about Lincoln is that coming from the Whig tradition, the Whigs had been strong believers in a weak presidency, right? And that was one of their great complaints against King Andrew and Jackson's use of presidential power. So there's sort of an irony, at least, in somebody coming out of that tradition becoming the most forceful and powerful president of his century.
One more.
I was just wondering, sir, what you thought the relevancy and value was in talking about secession in a constitutional context, because doesn't it seem on both sides like it was somewhat above that, with the secessionists considering themselves revolutionary and President Lincoln even classifying it as such in his first inaugural, and then on the unionist side you have them probably thinking it wasn't even an issue because it was obviously, I'm sure, considered illegal and unconstitutional with no government making provisions for its own destruction. So I was just curious about that. Your thoughts on it?
Well, I mean, there is the possibility that as an academic I got a little too deeply into the conceptual puzzles of secession, but I do think it had some practical significance. The Southerners were ambivalent. Sometimes they claimed to be revolutionaries overthrowing the government, but at least as often I think they claimed to be exercising their constitutional rights under the Constitution to secede. So I think that they were reluctant to rely entirely on the theory that the use of force is justified to achieve individual rights. And perhaps one reason for that is that you wouldn't have to think too hard about the implications. I think they were less important than the North. Once the South fired on Fort Sumter, I think that it became kind of a theoretical issue from the point of view of the North, you know, as it would be if anybody else had attacked one of our forts. So I think after the guns began to fire, it receded in importance. But in the decade or so leading up, or actually several decades leading up to the Civil War, I think it was an important part of the political and intellectual debate that in turn helped shape what came out of the Civil War. And it's what came out of the Civil War that is what we live with today.
Thank you very much.
Thank you.